Arizona lawmakers are taking a big step towards repealing a near total abortion ban. Earlier this month, that state Supreme Court ruled an 1864 law can go into effect, banning almost all abortions unless a woman's life is in danger. There are no exceptions for rape or incest. Yesterday, the state house passed a bill to repeal that law. 3 Republicans joined all Democrats to push it through. The bill now goes to the Arizona State Senate, which is expected to pass it. The governor has already said she will sign the bill into law.
Now, meanwhile, justices on the nation's highest court are divided over a major abortion case. Justices heard arguments yesterday in this case, which centers around Idaho's law banning most abortions in the state except in cases of incest, rape, and when a woman's life is in danger.
Leaders with the Biden administration say federal law requires hospitals to perform an abortion if a doctor determines a woman's life or health is at risk. They argue a delay on this decision will increase her chances of dying. Attorneys for Idaho say the Biden administration is overstepping its authority.
The Supreme Court's decision will impact the care hospitals can provide in 14 states that now ban almost all abortions with limited exceptions. We aren't expecting a decision in this case until June.
Queen City News Chief Legal Analyst Khalif Rhodes joining us this morning with the impact. Of course, we've got to wait now. Once those arguments are done, how do you see this playing out?
This is a very great argument. This is a great law school debate because in law school they give you these tests where they throw these red herrings. In this case, the red herring is abortion. Even though it's the buzzword, even though everyone's watching it because it seems to center around abortion, this is really not an abortion case. This is more about a states' rights case as opposed to this federal law preempt state law. This state law that Idaho enacted is attempting to say that doctors cannot save a person's life, even if they are deteriorating, if abortion is the only option, that they have to wait till that person is about to die. But that federal law, EMTALA specifically, is something that was put in place that they have to stop and they have to provide emergency care. So where the law for the federal law says that you must, and Idaho law says that you can't, the courts are debating and arguing, well, which one trumps? Typically, if it was any other case, this wouldn't even be a debate. Typically, federal law would supersede state law would step aside, and you'd have to do what the federal law says. However, because abortion is now involved, people are making this issue way more complex than it needs to be. And that's the argument that you heard yesterday. Even Justice Barrett said, listen, I am confused on how we get there. Please walk me through the argument, how you go and say that Idaho state law can supersede. And the argument from the state was that it's the way that you are interpreting what EMTALA, that federal rule, says that hospitals are supposed to do.
Khalif, where does this all end? And I mean by saying that when the Supreme Court overturned Roe v. Wade, it opened up Pandora's box. Now we see state challenges going to the Supreme Court, one after another. When does this end? Because I feel like it's going to be another state law, all the way going up to the Supreme Court.
Well, that's what exactly, when Roe v. Wade was overturned, all of the folks that said that was a bad idea said that you will have a floodgate. Pandora's box will be open in a floodgate of state legislators doing their own decisions, because Roe v. Wade said that there was no constitutional protection for abortion and that states could make a determination. But when you allow states to do it on an individual basis, which there's nothing wrong with, you can have legal challenges to ensure that those states are implementing things that fall within constitutional regulations. Specifically, something like this seems like it's a violation of a federal rule, which normally you could not have. And people don't like history. And so we have to remember, why do we have EMTALA? Well, in the 80s, folks were going to private hospitals. Private hospitals were rejecting them and sending them back to their own local hospitals where they were dying because they didn't have the adequate care. And so then in response, the federal government came out and said, hey, maybe we shouldn't do that. Maybe we should ensure that if you go to a hospital, regardless if you have the money, you should be able to get emergency care. Hence EMTALA getting enacted. But now states are saying, does that apply to abortions? Well, if abortions is the key to saving that person's life, you would assume that that would be something that would be applicable. And that's the argument that's in debate.
Like so many of these Supreme Court decisions, we have to wait a few more months until June or July. Khalif, thank you for that.